Hey everyone, welcome to Taking the Pulse, a healthcare and life sciences video podcast. I am Heather Hoops Matthews here in the studio today and joining remotely with my colleague Lauren DeMoss. She is a Maynard Nexsen lawyer in our Birmingham office. Lauren, good to be with you.
Thanks so much, Heather. Great to be here.
And we are also joined by our other Maynard Nexsen colleague, Erica Barnes. She is an attorney in the Birmingham office, and she practices in the criminal law spectrum in the areas of government investigations, criminal prosecutions, and civil litigation. Erica, thank you for joining us today.
Yes, thrilled to be here.
Tell us a little bit about your practice, if you don't mind, to start us off, and how it's evolved over the past few years.
Right. Well, we're a little bit of a confusing animal in law firms. People don't know what to call us. So some people call me a white collar lawyer. Some people call me a government investigations lawyer. But for street people, laymen, what I really do is help businesses and business people understand how criminal laws might impact them. And on a day-to-day basis, that really means I do one of four things most of the time. I'm either advising my clients on criminal laws that impact business, things like the Anti-Kickback Statute that we're going to be talking about today, or I'm conducting internal investigations to help those clients sort of figure out if they've broken the law before the government figures it out. I'm helping people who get requests either for documents or interviews. No one wants to go talk to the FBI alone. Or in the worst case scenario, I'm actually defending clients who have been charged criminally or who are involved in civil litigation where the government is a litigant.
And I suppose over the past few years, that maybe ebbs and flows based on what's going on in the world.
Absolutely. Most of my work is with the Department of Justice. So the Attorney General is a political appointee, as are all of the United States attorneys. So the political priorities of the day really do have a huge impact on what we do. After the '08 financial crisis, you're going to see a lot of emphasis and focus on bankers. These days, we've got a lot of focus on COVID-related frauds or reducing cost in the healthcare space. Whatever is politically expedient, that's what the government's going to focus on. And they're also going to sort of change their priorities politically. So what we've seen recently that I think is pretty interesting is just the increased nature of criminalization, period, right? There are more things that business people are doing that are now criminal law violations as opposed to regulatory or civil violations. And that's a sort of tough on white collar crime perspective or approach, I guess you could say.
Interesting. Thank you.
When folks hear criminal, I think their ears perk up a little bit, right?
Yes.
I think everyone's does. And you kind of talk generally about what you do. Can you give us some examples of the types of clients that are kind of specific to the healthcare industry that you worked with? I know there's a pretty broad range there of the folks you've worked with. And I think it'd be helpful for listeners to hear, who all can kind of get pulled in here in your world.
It's really anybody and everybody. So over the last 15 years of doing this work, I've worked with large hospital systems in urban environments down to one doctor practices in rural areas. So I represent companies, and a lot of those right now are DME or durable medical equipment companies, lab companies, testing companies, physician practices, dental practices, pharmacies, truly every kind of healthcare company that you could think of. And then I also represent individuals, both providers in terms of physicians, dentists, pharmacists, but also healthcare executives. And right now I'm seeing a lot of medical sales. So I represent a lot of individuals who are actually selling healthcare products either on their own or within organizations. To give you an example of sort of how it really depends on what the government is interested in. In the Southeast, where most of my practice is focused, the government has been targeting compounds, compound drugs and pharmacies the last 5 years. So I've represented the pharmacy that manufactures the drugs. I have represented silent investors and public investors in compound pharmacies. I've represented compound pharmacy salespeople, people who do compound pharmacy marketing, doctors who write the compounds, pharmacists who fill the compounds. So it really can be everybody that's involved in a healthcare business.
I guess that means everybody's at risk.
everybody's at risk, which is, I guess, good for lawyers and not good for everybody else.
Right. You also mentioned at the beginning the Anti-Kickback Statute. If you would, just give us an overview of what that is and how that might apply.
Absolutely. When Lauren asked me today, what do you think is impacting most of your clients the most right now? And I said the AKS, or the Anti-Kickback Statute. For those who aren't familiar with it, it's a criminal law that essentially prohibits healthcare businesses from giving anything of value, right? It could be cash money, but it could be free labor, free office space, anything of value to get healthcare business or to keep it. And it also prohibits you from accepting anything based on having given healthcare business. So anything that you would think of as a sales practice can essentially be prohibited by the AKS if it doesn't fall into a very detailed set of rules. It carries up to 10 years of jail time, along with really, really meaningful fines. And it can be used as a basis for criminal healthcare fraud charges and for civil False Claims Act charges. So it's a very, very scary statute. And it's being increasingly applied to a broader and broader sector of healthcare folks.
Are typical marketing activities allowed, like dinners, but you're talking about things that are of greater value, maybe a trip?
Unfortunately, even dinners can come into play. So some of the most common questions that we're going to get from people who are very attuned to these issues, they're going to be calling me and asking me, Laura and I had a client where we dealt with this a few weeks ago. Who can I comp to my conference? Who can I give free accommodations?
Oh.
Who can I, so things as small as that.
Wow. To
things as large as, full compensation, commission arrangements for salespeople, things like that.
Okay. Wow,
yeah. When you take that, as Erica explained, and it's so broad an application, and then you take kind of the types of providers, suppliers, entities that touch the healthcare industry. It's very broad in terms of the, who it can touch and how it can touch someone. So Erica, in terms of the AKS, what are some of the recent enforcement trends you're seeing, and are any, specific to a certain type of provider or supplier?
Well, I think in the Southeast particularly, and I was looking at South Carolina just this morning because my practice is traditionally Texas, Mississippi, Alabama, Tennessee, Florida. And obviously with the Nexsen Maynard merger, I'm getting more into the Carolinas. And South Carolina's had the same problems that the other markets that I'm in have had, which is they're focusing on any kind of healthcare product that's traditionally been sold, particularly with outside marketers. So right now, that's a lot of durable medical equipment. It's a lot of lab. It's a lot of any kind of testing, whether that's genetic testing, cancer testing, pharmacy products, anything where you're going to use an outside sales force or what I call traditional sales and marketing practices to sell something. That's been a real focus. One of the scariest things for me is the increased focus on individuals, right? And the increased focus on small businesses. So, our larger, more sophisticated healthcare clients, they're engaged with these issues. They know this statute. They are coming to lawyers like Lauren and I all the time and asking these types of questions. And they have a lot of in-house resources and compliance resources to make sure that they stay on the right side of this very, very complicated law. But a lot of healthcare products are sold by fairly small businesses, down to even individuals, working as contract sales reps. And those people don't know this law and they don't know how to go get legal counsel. And those are the people that I'm seeing increasingly targeted criminally. Small physician practices that might be accepting various kinds of compensation in connection with their vendors. So it's really unfortunate. The people who are being targeted the most are probably the people who know the least about the dangers inherent in the law.
I should probably know this, but is this criminal or civil?
It can be both, and that's what makes it.
Okay.
So the Anti-Kickback Statute is actually a criminal law. So it carries, again, up to 10 years in jail, criminal penalties, criminal fines and penalties. But as a double whammy, it can be used as a basis to bring civil False Claims Act litigation. And if you're not as familiar with the False Claims Act in the way that Lauren and I maybe are, it's one of the scariest civil laws because the penalties are 3 times the damages to the government, plus additional fines and fees. And so if you don't get hit with the AKS on the criminal side, the government will often use it to say, all of the claims that you submitted to us are false and we shouldn't have paid them because you got this business based on a kickback violation.
Whoa, that would be bet the company then, I assume.
Most of the time it is. And again, particularly for large companies, I mean, you routinely see multi-million-dollar settlements in this space. And for small companies, again, many of my clients who are maybe smaller labs, startup medical sales organizations, it ends their business. If they end up facing one of these cases civilly and it goes the wrong way, it's business ending. And obviously, if the founder or primary executive is charged criminally, it's also business ending.
And I think a big takeaway there, Erica, too, is, I think people are maybe, it's not correct to think that the government's going to focus on the big fish, right, in the pond. They are focused on anyone and everyone. And so even the smaller providers, like you said, are, can be tripped up by this statute. And I know when we're given, folks come to us with anti-kickback questions under the federal anti-kickback statute, its application is direct if you're billing a government payer. And that's obviously one of the first questions we often ask in terms of an anti-kickback analysis. But if you don't bill government payers, do you really need to worry about the anti-kickback statute?
Unfortunately, the answer is yes. So, maybe 10 years ago, maybe even as recently as 5, I would see clients and they would actually treat products that they were billing to federal payers different than products that maybe were cash pay or that were going through commercial payers. Well, the government saw that and they don't like it, right? They don't like this sort of, we're getting around the AKS by engaging in certain sales practices with our private pay, but not government. So they're being increasingly aggressive and using different strategies to get around that problem and to get to people who are engaging in what one might think of as AKS type activity, but just with private payers. They can charge them with healthcare fraud instead of kickback statute violations. There's a number of different state statutes and civil statutes, but the old rule, as long as I don't bill the government, I'm fine, just doesn't seem to really apply anymore. And Lauren, something you were saying about small versus large that I think is interesting / scary to me is one of the biggest changes I've seen in this space in the last 10 years is the government's focus on requiring people to police themselves, right? So now the expectation is you should have a compliance program. You should make sure you're not doing this. If you're doing it, you should investigate it yourself. And then you should come and tell us you did it. Turn yourself in. And if you're not doing that, your penalties are going to be twice as hard. Well, again, for our big clients, that's a possibility, right? They can investigate, they can do this sort of self-disclosure process. But for most of our small clients, they either can't do it or they don't know to do it. So then when they get hit, they're getting hit with penalties that are twice as hard because they failed to sort of police themselves.
Yeah, and that's a great point about policing, and trying to get ahead of it. And you think about, folks are most often coming to you when a problem's been uncovered, right? And ideally, I think, at least in as our worlds kind of connect, you want to kind of get ahead of it and be proactive. So what are your kind of recommendations when you think about folks hearing about enforcement trends and wanting to get ahead of it and not, getting down the road where the government's called and they're under investigation?
Absolutely. So I think the number one thing is to be educated about the law, the number and how it's being enforced in your industry. And that might be a formal CLE or a meeting with a lawyer, or it might be just reading industry publications. But the number of my clients who come to me who did things in violation of this law and they literally had no idea the law existed, right? Or what it punished. So I think you got to get informed. And then unfortunately, I think you got to get legal advice, right? Mm-hmm. Nobody wants to run to the lawyer. And I say this not as a business development technique, but truly a pound of prevention is sort of situation. But this law is so complicated that if you don't seek advice on the front end about, what marketing plans do you have? How do you plan to compensate your salespeople? It's really difficult to fix it on the back end. So people have got to get legal advice. And then the other thing I'd say is if you are in the healthcare space, and it doesn't matter if you're a big hospital chain or if you are selling pain sprays out of the back of your car, you've got to have a compliance plan of some kind. And I think most people think, hey, a compliance program, that's like a bunch of people and that costs a lot of money. A compliance plan can be as simple as you and a binder. All a compliance plan is a plan on how to not violate the law, right? How am I going to make sure that I stay on the right side of the line? What is my plan for that? And depending on the size of your business and your risk, that may be something that you really need legal help to develop. It may be something you can go to a consultant. It may be something that, an industry group can help you put together. But having no plan is not an option if you in any way deal with federal healthcare payers. It's just the cost of doing business. It's something that people have got to do.
Yeah, and Erica, as you talk about it, it comes to my mind as you think about innovation in the healthcare space right now, and just the startups and companies that are looking for new ways, delivery of care, access to care, and those companies too are touching. This statute can touch them too, and they need a compliance plan the same way as your kind of traditional large health system, hospital, physician group practice need one. So it really is. It runs the full gamut of the types of folks that the Anti-Kickback Statute can touch.
And on that point, Lauren, I know we may not have much time here, but I just want to point out, because we haven't talked about it, that even clients who don't directly bill, right? And that goes into some of that healthcare tech that we've been talking about, right? Maybe healthcare companies that provide a service, some sort of accounts management, accounts payable management, software, things like that. This law does impact them as well. And they people tend to forget that. They think if they're not the ones directly submitting claims, they're off the hook. And that's not the case.
Yeah, that's an important point. As we wrap up, Erica, just a couple kind of scenarios that you can share of, kind of worst case scenario phone calls that you may have received or that you don't want to receive, right? In this area, in terms of, not that we've scared everyone enough already as it is, but thinking through kind of worst case scenario, these are the things that keep you up at night and should probably keep folks in the healthcare space up at night.
Yeah. So as a criminal lawyer, right, I've got my phone. It's never turned off. And the call that I never want to get is the 6 a.m. search warrant, right? I don't want to get a client who calls me at 6 a.m. because the FBI is there searching their business, right? And the double whammy is if they call me 2 hours after the search warrant happened and they've already given a 2-hour interview to HHS or FBI. So that's usually my nightmare scenario. But the other one, and unfortunately this one is much more common, is when a client calls me and they have violated the law. The government has them dead to rights. They didn't know what they were doing. But unfortunately, they made no effort at compliance and they made no effort to get legal advice on the front end. So now I've got a clearly guilty client and I have no arguments in favor of mitigation or anything to sort of help the problem. And that's a really sad day, right? Because I can look at the person and say, I understand you didn't know, but ignorance is not a defense. And now we don't have anything to argue about. If you had called me 6 months ago, a year ago, maybe we could have, in most cases, we can fix it. Most people can do what they want to do within the bounds of the law. They just need a little advice on how to do it.
Well, to your point, a good compliance plan would kind of have the procedures and protocols kind of in place, and how to handle that 6 a.m. search warrant, and how,
Yes.
how to discuss talking to the government. So it underscores the need to have that in place ahead of time.
Although the number one thing, Lauren, is not talking to the government. It's calling me first.
Call Erica first. That is the most important thing.
My cell phone is on the website. Call me
That's
first.
right. I'm just sitting here thinking, thank goodness I'm not in the healthcare industry trying to sell something, because I'm sure I would make a mistake or get something wrong without your help. Erica, if I had your help, I would nail it, I'm sure. Erica Barnes, a criminal lawyer serving in a wide spectrum at Maynard Nexsen, based in the Birmingham office, but serving the Southeast and beyond. Thank you so much for joining us today. I've learned a lot, and a little terrified for some people who may not know criminal and civil. That's a double whammy. But we thank you for your time.
Thank you for having me. It's been great to be with you.
Thank you, Erica.
On behalf of Lauren and the whole team here at Taking the Pulse, we thank you for joining us today. Hope you learned, if you're in the healthcare industry, we hope you learned a little bit about the Anti-Kickback Statute. And we look forward to seeing you next time right here on Taking the Pulse, a life sciences and healthcare video podcast.